What are the requirements that a person must meet in order to file for divorce in Virginia? Is it only the plaintiff or the person who's initiating the suit that can meet those requirements, or can the defendant or the person responding to the suit meet those requirements? Are there any sort of domicile or residency requirements in order to file for a divorce? If there are, what purpose do they serve, or what's the reason for those requirements? Those are some of the questions that we're going to address today. I'm Michael Miller. I'm a partner at Cole Miller PLLC. We're a family law firm located in Vienna, Virginia, practicing only family law in Virginia. I analyze complex family law situations and find affordable solutions. If you would please subscribe to this YouTube channel, and if you could also provide any kind of comments or feedback. I monitor and review all those, and so your comments and input would be helpful in developing future presentations. So the key statute we're going to talk about today is Virginia Code 20-97, and it's titled Domicile and Residential Requirements for Suits for Annulment, Affirmance, or Divorce. Now, we primarily see this in divorce. In my 20 plus years of practice, there's been maybe 3 occasions where there's actually been a legitimate annulment basis there. So everybody talks about annulments, but very rarely do the facts come together for a proper case to proceed on an annulment basis. So by and large, in my experience, this is going to be for divorce cases. And if you see a divorce complaint, one of the first things that will be alleged after the date and place of marriage will be that either one or both of the parties is a bona fide resident and domiciliary of the Commonwealth of Virginia. And that's because this statute requires it. Virginia Code 20-97 says that no suit for annulling a marriage or for divorce shall be maintainable unless one of the parties was at the time of the filing of the suit and had been for at least 6 months preceding the filing of the suit an actual bona fide resident and domiciliary of the Commonwealth. So there's a couple things in there that we have to look at. First of all, it has to be for the 6-month period preceding filing the suit. So you can't come here from Maryland from out of state and file here. You have to have been here for the 6 months preceding. Now, it only says it has to be one of the parties. It doesn't have to be the plaintiff. So if the parties were living here in Virginia together and the future plaintiff moves out of state, they can proceed in filing a divorce in Virginia using the defendant's residence and domicile as the basis for the suit. And in some coming presentations, we're going to talk about jurisdiction. And so there would be reasons why a plaintiff would initiate a suit in Virginia in order for the defendant, who would be subject to the personal jurisdiction of the court, to be able to be brought in before the court. Now, this 6-month requirement is only has to be met at the time the suit is filed. So this happens frequently too, is we have 2 spouses who have decided to divorce. The one wants to move out of state, so we have them stay here in Virginia, file their suit. Then once their suit is filed, then they're free to go on and leave the state. And then they can proceed to litigate here in Virginia in the coming months. Also, once this goes into the complaint for divorce at a later date, there will be required testimony, either offered in court or attendance. It could be done by deposition or it could be done by affidavit, where the plaintiff and a witness would have to establish the residence and domicile requirements here. By and large, a person can have many residences, but you can only have one domicile. And so what you want to look at is, domicile is kind of the place you always have the intent to return if you were to be away. They also look at things such as voter registration, driver's license, where you have your bank accounts, where you pay your taxes, where your vehicles are registered, and through all those sort of things. So it's kind of, there's not one right line or checkbox, but you kind of look at the totality of what there is there to try to establish that one of the people is a resident or domicile of Virginia so the case can proceed. Now, the reason for that is to stop kind of the forum shopping or people, traveling around trying to get the quickie divorces, or to also to safeguard people's rights and interest by preventing a spouse from running off into some unknown or unexpected state and filing for divorce there without the defendant being aware that this divorce case is going on, or even being aware or even expecting that a divorce case could proceed in this other state. So that's the safeguard that's built in there. Also, courts are funded by the taxpayers of the state, and so we don't want state resources being spent for people who aren't in the state paying taxes and so forth. So that's a quick overview. To answer the question, yes, you do have to be a bona fide resident and a domiciliary. You have to have both of them of the Commonwealth of Virginia in order to file your suit. Now, a coming video, we're going to talk about some special exceptions that are made for service members and given the relationship to the Service Member Civil Relief Act. But for today, this will wrap up our requirement on the domicile and residency requirements for divorce. If you would, please subscribe to our channel. If you find us on other social media, go ahead and like and follow us there. And in the final screen here, I'll go ahead and put links so you can subscribe to our channel or watch another video that I believe will be relevant to this that would be informative for you to follow up on.